5 seconds to go. Start. This is a statutory appeal before us under Section 125 of the Indian Electricity Act 2003. It registers a challenge to the judgment and order dated 27 September 2019 passed by the Appellate Tribunal for Electricity dismissing an appeal carried under Section 111 of the Electricity Act by the appellant from the judgment and order dated 15th February 2016 passed by the Telangana State Electricity Regulatory Commission. Consequently, the impugned judgment and order of the TSERC was upheld. The basic facts giving rise to this appeal are not disputed. A brief overview of the facts and the trajectory of proceedings relevant for a decision on the present appeal are set out hereunder. The appellant was notified by the Ministry of Commerce and Industry, Department of Commerce, Government of India as a developer in terms of Sections 3 and 4 of the Special Economic Zones Act 2005 to establish a sector-specific Special Economic Zone unit for information technology enabled services sector in Madhapur, Rangareddy district, Hyderabad, in the former state of Andhra Pradesh. MOCI wide a notification bearing number SO 528E dated 3rd March 2010 introduced a proviso to Section 14B of the Electricity Act. The proviso accords upon the developer of a SEZ the status of a deemed distribution licensee under the provisions of the Electricity Act. Pursuant to the 2010 notification, the appellant filed an application before the erstwhile Andhra Pradesh Electricity Regulatory Commission seeking identification as a deemed distribution licensee in terms of the proviso to Section 14B of the Electricity Act read with Regulation 13 and Schedule 2 of the Andhra Pradesh Electricity Regulatory Commission Distribution License Regulations 2013 and Section 49 of the SEZ Act. Upon the Andhra Pradesh Reorganization Act 2014 coming into force, the application was transferred to the TSERC. By its aforesaid judgment and order dated 15th February 2016, the TSERC identified and accorded the status of a deemed licensee to the appellant. However, this grant of status was made conditional upon the appellant satisfying the requirements stipulated in Rule 3 of the Distribution of Electricity License, additional requirements of capital adequacy, creditworthiness, and Code of Conduct Rules 2005, compliance whereof was mandatory per Regulation 12, which stipulates that an applicant for grant of distribution license shall, addition to Regulations 4 to 11, comply with the 2005 rules read with Regulation 49 of the 2013 regulations, which stipulates that all the general conditions applicable to a distribution licensee are also equally applicable to a deemed licensee. The appellant was therefore directed to infuse an additional capital of Rs 26.90 crore as equity share capital contributed by its promoters into its power distribution business via account pay checks by 31st March 2016. The relevant part of the judgment and order of the TSERC is extracted hereunder. On a close reading of the provisions of Section 14, we are of the view that the provisos to Section 14 are not applicable to a deemed licensee. The status of a deemed license to a person under Section 14B of the Electricity Act 2003 emanates from the notification given under Section 49(1) of the SEZ Act to a developer of SEZ provided the deemed licensee satisfy the other provisions of the Act. We are of the view that the provisions contained in subsection 2, 3, 4, 5 and 6 of section 15 of the Act are not applicable to a deemed licensee. Stop.